Hi everyone, it's Chris Gibbs here from ICGTAX in Sydney. Now we continue to get a lot of inquiries about the coronavirus economic relief package and in particular to the Jobkeeper Payment, which is the single largest budget item ever passed by Parliament. This short presentation sets out the current state of the law and what still needs to be done for this support to be made available to employers and for the employers to be able to make the appropriate payment onto the employees. Last night, Parliament passed a number of coronavirus economic response acts. And these passed both houses in short order and without any amendments, as both parties were concerned to have them in place quickly to give some confidence to the community. The JobKeeper payment was announced last week on 30th of March 2020 and is designed as both a social welfare and a business continuity measure simultaneously. So, to be delivered through the ATO, it aims to support continued income for employees of businesses affected by coronavirus and to keep them in touch with businesses to facilitate a more rapid and stronger recovery when the medical and health conditions allow everyone to return back to work. The JobKeeper payment is a cash payment to businesses to support continuing payments of $1,500 a fortnight for up to 6 months for eligible employees. Now, it is important to note that this is legally a payment to the business and it's to support payments made by that business to its employees. It's not a payment directly to the employee. The employee may be one who is continuing to work in the business, or one who's been stood down, or even one who's been previously terminated and rehired. Now, the bulk of the legislation is aimed at changes to the Fair Work Act, which are to enable employers to change the terms of the employee's engagement, such as hours, location, specific tasks, etc. This presentation doesn't deal with the employment law aspects of this act, but merely with the JobKeeper payment aspects. Businesses will be eligible if they suffer a fall in revenue of 30% or 50% for businesses with greater than $1 billion in revenue. There's no size limit on the businesses that may apply, and as the amount is per each employee in the workforce of that business, the amount available for the businesses are very large. And the fiscal impact of this is projected to be $40 billion between now and 30 June, and another $90 billion by the end of October. $130 billion in total budgeted on this item. Now, there was a lot of waiting excitedly for this legislation to be tabled, to be seen. It was hoped that it would have clarified a lot of the questions that have been left after last week's announcement. However, it quickly became clear that this legislation is purely enabling legislation. It leaves the entirety of the JobKeeper scheme to be provided for in rules which will be created by legislative instrument to be made by the Treasurer at a later date. In context, we've got a $130 billion bill here, and the small writing at the top is the operative provisions within the legislation that enable this payment to be made. That is two subsections effectively. Subsection 7 of the bill, or of the Act, sorry, which states that the rules may make provision for and in relation to one or more kinds of payment by the Commonwealth to an entity in respect of a time that occurs during the prescribed period, and the establishment of a scheme for providing for matters relating to those payments. And section 20 states, the Treasurer may, by legislative instrument, make rules prescribing matters required or permitted by this Act to be prescribed by the rules. So, effectively, the entirety of $130 billion is dependent on rules which are to be announced by the Treasurer, made by way of legislative instrument under the power of the Treasurer. We're uncertain what those rules are at this point in time, and legislative instruments used to be called regulations, but legislative instruments must be tabled in Parliament within 6 sitting days of their being made. And Parliament is not sitting again until October. So strictly speaking, these don't need to be tabled and can't get any parliamentary scrutiny for 6 months. This is an extraordinary level of authority and budget given to the Treasurer, No doubt there'll be a lot of lobbying goes on, and the rules can be subject to constant change throughout this period. Now, as the rules for the JobKeeper scheme haven't actually been released, let alone tabled in Parliament, we can really only go off the announcement that was made by Treasury last week in a press release as to what is expected. But until such time as these are actually rules made by way of legislative instrument, there is no power for the Commissioner to make any payments under this law. This is despite the fact that the government announcements, certainly the press conferences, are encouraging businesses to start making these payments to their employees immediately, even if it passes on time, the first payments won't be made until early May. What in fact does the legislation provide for, other than providing for the Treasurer to be able to make rules? Well, specifically in the legislation, it is clear that businesses must pay their employees before being eligible to receive the JobKeeper payment in relation to them. So that is potentially going to cause a cash flow issue. The payments which the government is saying you can make now won't be made until May, but any payment after that will need continuing financing, at least on a short-term basis, each fortnight. The legislation requires that there will be fairly severe record-keeping requirements, but those are going to be set out in the rules. And if you don't comply with the record-keeping requirements, then the amount is not eligible to be paid. There is an anti-avoidance provision, similar to Part 4A of the Income Tax Assessment Act, allowing the Commissioner to determine that an amount shall not be paid under this, where there was a scheme for the sole or dominant purpose of increasing or making eligible the JobKeeper payment. So beyond that, the rules of the JobKeeper payment program will be in a legislative instrument that does not yet exist and is completely at the power of the Treasurer to make the rules. So really what we've got to go off is the announcement from last week, and again noting that the announcement is not a legislative instrument and is not the formal rules. It stated that the requirements to receive the JobKeeper payment, the employer must register with the ATO and provide relevant details. Now, I note that the tax office website has a spot to be able to register your interest or your register interest in the program, and that all just requires that it's the company's name, a contact name, and the ABN number, and primarily that's in order to receive future correspondence in relation to this one. That further stuff is provided by the ATO. Okay, it's requested that you will you have to self-assess, or you assess that you will experience the required turnover decline, and that is that you are experiencing it or you are likely to experience it. You need to ensure that each eligible employee receives at least $1,500 a fortnight and notify that employee that they're receiving JobKeeper payments. It's quite clear from this that employees that are typically their salary is less than $1,500 a fortnight are still entitled or required to get $1,500 a fortnight in order to be an eligible employee to receive the JobKeeper payments. And this information needs to be updated on a monthly basis to the ATO. So there's potentially quite some level of administrative effort required to keep up to date with this. So the announcement states that eligible employers are ones who've experienced a reduction in turnover. Okay, for less than $1 billion annual turnover company, the turnover is that which is 30% either experienced or likely. For $1 billion company, it's 50% reduction in experienced or likely turnover. And for registered charities, a reduction in turnover of 15% that's likely or experienced. Businesses without employees are also mentioned in the information pack put out by Treasury. There is a little bit of ambiguity around this. At one point, it says businesses without employees, such as the self-employed, and in other parts of the press release, it talks about employed individuals, which are then assumed to be businesses without employees, being eligible if they suffer the decline in turnover. So it's not entirely clear at this point whether that was intended to be for the self-employed or that any business that does not have employees can claim the amount. Now, if you have no employees, then how are you paying it to an employee is the obvious question. You are required to designate an employee into whose bank account it can go. Obviously, you can only an employee can only receive one, but if there is a business out there that's got all the employees in a different business, potentially that business is available. But again, it's a little bit ambiguous due to the slight differences, and you need to keep an eye out for that. This item appears to be put in there primarily for the contractors that are throughout the construction industry. Construction industry supposedly employs about 1.1 million people in Australia, and a large number of those are the self-employed subcontractors who've got their own ABN number and no employees. Now, the measurement of the turnover is probably the critical item here. The intention is that it be done on the turnover for your BAS period against the corresponding period of last year. So if you're a quarterly BAS payment, it's the relevant quarter versus the quarter last year. If you're a monthly BAS payment, it's the monthly. Now, of course, there might have been business changes from last year to this. There might have been a consolidation. There might have been an acquisition of a business. You might be a new startup. There is commissioner's discretion to take these things into account, and the specifics will need to be done on a case-by-case basis and explained to the commissioner if that's the case. Importantly, when measuring turnover, they're saying it's going to be done off the BAS, and it will include GST, taxable supplies, and GST-free supplies, but it will not include input taxed supplies. Okay. Now that appears to be for both calculation of revenue and of the reduction in revenue. So whether you're above or below $1 billion does not appear to take overseas subsidiaries into account because it is only the ones in the consolidated group that are included on the BAS, or the calculation that's included in the BAS statement that's lodged. Consolidated groups which are putting in a single Australian income tax return, the required reduction in turnover is stated in this announcement to be required in relation to each company in the group. And it's not really clear how that is, whether that means that an internal company that's like an internal financing operation for somewhere else in the group might be not suffering a reduction in turnover due to the internal payments and therefore make the whole group ineligible. It would be surprising if that's the case, but the way that the announcement is framed at this point, it does appear to do that, and we'll watch that point carefully. So eligible employees are those who are currently employed by the eligible employer. They had to be employed as at 1 March 2020. They could be either full-time employees, part-time employees, or long-term casual. And the long-term casual is those who've had regular and systematic employment for greater than 12 months as at 1 March 2020. That item still appears to be a slight bone of contention with the Labor Party, who want the shorter period. That has been done to be in tone with the definition within the Fair Work Act. It may or may not be amended at some point in time. I think the government is fairly resolute on holding that for the time being. Need to be over 16 years of age. You need to be an Australian citizen or a permanent resident, or hold special visa class number 444, which is for New Zealanders only. You also need to be an Australian resident for tax purposes, and of course you can only receive Jobkeeper payments from a single employer. And if you've got two employers, one of them will notify, and you need to notify the other one that you're not eligible for it. There is not a definition contained in this legislation as to what an employee is. Note that in the earlier coronavirus boosting cash flow for employers, it wasn't done off the definition of employee, it was done off those who are receiving payments from which PAYG payments must be, PAYG withholdings must be withheld. So that includes directors' fees. It's not clear, I mean, directors are not considered employees at common law. It's not entirely clear whether they would be expected to be covered under this, or whether the employment definition for this is going to be off the common law definition of employment, or in fact the Fair Work definition of employment. So what do we still not know in relation to this? Well, quite a lot really, because again, the legislative instrument is not passed. So the only thing we've got to go off is a announcement from Treasury, and that announcement is not written in legalese. It doesn't define all the terms and so on. In particular, the difference between a below $1 billion business and above $1 billion business, how that's measured, is that aggregated with your international operations, or if you've got a small Australian subsidiary. Given that the point is to try and maintain employment relationships, it may be the case that a small Australian subsidiary of a giant multinational only has to suffer a 30% fall. I guess time will tell. We're also not certain how consolidated groups are required to show revenue decline on a single company basis. The announcement does say that it must be suffered by each company in the group. I'm not sure whether that means that internal eliminated entries for internal amounts or internal transactions need to be eliminated. But if it does, we might see some other companies being eliminated from the consolidated group or otherwise restructured in there. Passing that this is not available for companies that are in liquidation. It does not appear to disallow companies that are in administration or otherwise in distress, and I guess that's the entire point of it. Okay, and well, what do we know is the subject of lobbying at this point? We know that the Greens proposed an amendment to require rules to include provision for temporary visa holders. That was knocked back. Labor continues to voice concern about the 12-month rule for casual employees. The government seems to be fairly resolute on this one, and it's primarily in order to keep it in line with the definitions under the Fair Work Act. The Treasurer, though, because he is empowered to make rules for effectively for the next 6 months, we would expect would be subject to constant lobbying by various groups who feel that they have been unfairly missed out. And I guess it's a case of watch this space closely. So I guess it's watch this space for any future announcements. Certainly the fact that none of the rules have actually been written in correct legal language isn't going to, or is going to mean that there's going to be quite some analysis that needs to be done when they come through. But if you've got any specific questions in the meantime, drop me a note in the comment section below or contact ICGTAX. Thanks. Stay safe.